To start off, we need to be clear about what a contract is and what the objectives of contracts in procurement are. Following that, we will look at the definition of terms and conditions in contracts, some factors to take into account to ensure terms and conditions incorporated in the contracts are to be enforceable in the law. It is important to note at this stage that this course does not purport to provide you with legal advice. We are simply teaching the basics of contract writing for procurement. We ask that you do not use this course material as a replacement for legal advice. You should always seek legal advice from an expert lawyer in your local market or elsewhere to ensure the appropriate actions pertaining to your specific situation are taken. You must know that every jurisdiction will have its own legal framework applicable to the supply of goods and services, and to that end, local context is critical insofar as legal contracts and its enforceability are concerned. With that caveat out of the way, let's start off with the basic definition of a contract. A contract is simply an agreement between two or more parties which is intended to be enforceable by law. The key here is intention of the agreement being enforced by law. This means social agreements are different from contracts, as an agreement to clean the garden of a friend cannot be enforced by law if you fail to do so. However, where the agreement is between two commercial entities, there is a presumption in law that the intention is to enter into a legal relationship. The law of contracts is concerned with four basic questions. 1. The first question, is there a contract that is legally binding in existence? There must be a clear mutually understood agreement between parties in the form of an offer and an acceptance. One party, the offer should make a definite promise to be legally bound on specific terms, which is the offer. The other party, the offered, must accept the offer clearly, unconditionally, and freely without duress. Each party must suffer some kind of loss or detriment in return for the benefits received, and this is usually payment of money in exchange for goods. Each party should agree if there is a dispute, the court can be called upon to deal with the matter, and both sides must have the capacity to enter into a legally binding contract. In most cases, the law will use acid tests such as age of the parties and soundness of mind to determine capacity to enter into the contract. But equally, the authorization limit of the organization can also be used to ensure an organization is not exposed in law to fraudulent abuse of its staff entering into unauthorized contracts. Typically, the seller offers to sell, in the case of a tender, bid, or quotation, a specific service of goods for consideration, which the buyer accepts, for there to be an agreement with intention to enforce by law if there is a breach. This is why suppliers' bids are nothing more than an offer until they are accepted by the buying organization. What the buyer wants is set out in specification. The tender document is nothing more than an invitation for suppliers to make an offer. It is for this reason defining and communicating the buyer's requirements in a clear and unambiguous manner in specs is as important as it forms the heart of the contractual agreement subsequently, all things being equal. The second question, is the agreement one which the law should recognize and enforce? This is very important. Where there have been a mistake or misunderstanding, some contracts may be nullified wholly or in part. An agreement to supply services or goods that are unlawful cannot be enforced in law. Getting a supplier to agree to rob the bank, hack a computer network, or supply illegal drugs cannot be enforced by law if the supplier fails to perform, even if payment has been made for the services. 3. The third question. When do the obligations of the parties come to an end? Usually this happens when both sides have fulfilled their part in the contract. However, when one party is in breach of the essential terms of the contract, this will give rise to termination of the contract automatically. 4. The fourth and final question. What remedies are available for the injured party if the other party fails to meet its contractual obligations? This can be termination of the contract with no obligation on the injured party to fulfill their side of the contract and claim monetary compensation for damage, i.e., losses suffered as a result of the failure. Let us now review what the role of commercial contracts are and what contract terms are. The role of contracts can be summarized as follows. 1. To formalize obligations and rights of the parties involved in the contract. 2. To control and allocate risk between parties. 3. To lock in benefits for suppliers as well as buyers. 4. To eliminate the need for negotiation, which can be time-consuming. 5. To agree on how exceptions will be handled from the onset. Contract terms are statements by the parties as to what they understood their rights and obligations to be under the legally binding contract. The terms can be express terms or implied terms. Express terms are clearly stated and recognized in the contract between the parties. This may include such details as the items to be supplied, the specific price, delivery dates and place of delivery, the quantity to be supplied, how carriage and insurance costs will be shared, what the quality of the product should be, and so on. Another example of express terms is limited liability clauses or force majeure clauses, which exclude a party from the obligation in the event of a specific